nonprofit law firm was committed to assisting grassroots organizations across the state of Pennsylvania, which is where I went to law school, to stop or try to stop projects coming into their communities. And those projects were all kinds of things, from toxic waste incinerators to large-scale hog factory farms, to hydrofracking for natural gas and oil, to toxic waste landfills, basically any of it, thousands of different kinds of projects that communities don't want in their communities. We set up a law firm back in 1995, fresh out of law school, to provide free legal services to those communities as they were trying to stop these types of projects from coming into their neighborhoods and into their municipalities. And so for a number of years, we did what I lovingly refer back to as conventional or traditional environmental law. And what does that mean when I say traditional environmental law? Well, it's what environmental lawyers do today, which is that a permit gets issued to a particular corporation, and usually it's a corporation, to do a particular project, like a toxic waste incinerator, a factory farm, or whatever. Environmental lawyers kind of come in after the fact. The permit's been issued. We're asked to challenge the issuance of the permit by the state agency. In our case, we were representing very small grassroots environmental organizations in very rural areas in the state of Pennsylvania. And our job is pretty much always the same, which is you take the state environmental regulations, or federal, the regulations underneath which the permits have been issued, and you study them and compare the corporate permit application against those permit regulations, with the goal of trying to make the argument that there are gaps, omissions, or deficiencies in the permit application that's been issued, the permit that was issued, that there are gaps, omissions, and deficiencies in the application itself, and therefore the state agency made an error. They made a mistake. They erred in issuing the permit because there were certain things missing from the permit application. So just to come down from this 30,000 foot level to practical stuff, we'd be looking through corporate permit applications for a missing signature, or a bond amount that wasn't posted correctly, or a macroinvertebrate water study that had been updated, that was done within the last 10 years. And we'd be arguing to judges, in front of judges for those 10 years, we would be arguing, Your Honor, under section little 2, little c, little I, little 2, little Roman numeral 2, little d, little c, little I, little 2, that a signature was missing on page 24, line 50 of the permit application that the corporation had submitted. So that something was missing, and it didn't comply with the state environmental or federal environmental regulations, and therefore the permit shouldn't have been issued in the first place. We were asking a judge to overturn the permit. And just because sometimes the the best thing you can do is show up. Sometimes showing up is everything, because 90% of permits that are issued in the United States are never appealed, mostly because communities don't have the resources to actually appeal permits at the local level. So most permits that are issued are never appealed. So sometimes just by showing up, that's the victory. And we would do our homework and find these things. The judge would agree with us. He'd throw out the permit for the operation. And what would happen next? Well, 30 or 60 days from the date of that hearing, the corporation would come back and they would have a new and improved permit application using the gaps and omissions and deficiencies that we had found and fixing those within the permit application. So they now had a new and improved permit application. And then the community group would come back to us and say, Mr. Linzey, we need you to do that jujitsu again that you did the first time around to get that permit out, to get that permit overturned. And we would end up in the very frustrating place of responding to them that there was really nothing we could do because all the leverage points were gone. Those gaps, omissions, and deficiencies that we had tried to find earlier had been fixed. They had been filled. And what would happen 30, 60, 90 days later, of course, would be that the community would get the project. They would get the factory farm. They would get the toxic waste incinerator. That is the story kind of environmental regulation in the United States today, that it really doesn't stop anything. And it may carve some of the rough edges off or cause project designs in some cases, but it really doesn't stop anything. And we had to learn some things the hard way. One was that after we had won these permit appeals, we would have the law firms of some of the largest corporations coming over to us, thanking us for finding the gaps, omissions, and deficiencies, because then they could bill the corporations more hours to fill in the gaps, omissions, and deficiencies that we had found. So they actually came over to us and thanked us for the permit appeal and going through this process. We at least thought we were costing these companies money, and we were up against some of the largest ones, Monsanto, Chemical Waste Management, Waste Management. We thought we were costing them money because they had to hire lawyers to come in to do the defense on the permit issuances. It was then that we learned that the monies that the corporations spend to defend their permit issuances is tax deductible under the tax code as a reasonable and necessary business expense for the corporation to write off. So in essence, part of this is structural. It's about the corporations having the benefit of those tax deductions that, of course, the local communities don't have. So when we or local community groups come together to actually do a permit challenge, not like they can write off those costs, but the corporations defending the permits can. It's part of this structural thing around how this process works. And the other thing that somebody told me at the time, which I brushed off, and I still remember to today because the person that told it to me was much smarter at that point in time than I was, which was, she said, the only thing environmental regulations regulate are environmentalists. The only thing that environmental regulations regulate are environmentalists, because the regulations themselves make it predictable as to how we defend against the permit issuances. And although we don't say this to ourselves frequently, or we don't like to admit it, but it's the regulated corporations that are generally the ones writing the regulations that ostensibly they're being regulated by. It's not like the rural communities that we were representing had a chair at the table for the development of the regulations that were regulating these particular industries. And I worked in the Capitol in Pennsylvania for a number of years. I actually saw the agribusiness corporations writing legislation, handing it off to the House and Senate committees, or working with the regulatory agencies and bodies to write the regulations. If we think that the regulated corporations are writing stuff in to allow us to veto the projects that they're attempting to bring into communities, how insane is that? How insane does that make us that we continue to play the game the same way when the script was not written by us or our clients that we're representing, but were written by the very corporations that are ostensibly supposed to be regulated by the regulations that they themselves are writing? So the whole thing is kind of like whack-a-mole. I don't know if anybody's been to a county fair where you have the game whack-a-mole, you hit one of the moles and then another one pops up, then 6 more pop up. But essentially, whether you either use that as a mental picture or as a hamster running around a wheel, that the environmental regulations and the regulatory process are kind of set up to exhaust us. And so when the person, Jane Ann Morris, who's no longer with us, but she was a corporate historian, that's how she built herself. When she said the only thing environmental regulations regulate is environmentalists, I think she kind of hit it right on the head. So again, so what? Right? We have this system, we can complain about it and criticize it, but so what? It's a system that we have. Well, it led me, after about a decade, and other lawyers who we work with today on these issues, to really re-examine the foundation of environmental law itself. And the system of environmental law that we have in the United States, the system of law that we have in the United States, is a Western European system of law. As much as we like to think about, some of us, I guess, picking up muskets in 1776 and breaking free of England, the truth of the matter is that we kind of transported whole this English system of law, because it was what the lawyers knew when they wrote the Constitution, and a lot of the early lawmaking and Supreme Court stuff. It's all around this European English system of law. And one of the problems with the English system of law is it sees nature as dead. It sees nature as a dead thing, as an inanimate object. It doesn't factor into Western law. If you look at the US Constitution, you won't find the word nature anywhere, let alone the word ecosystem. It's inanimate. So you have phrases in our culture like people will refer to land as undeveloped. Oh, that's undeveloped land. Well, maybe it's been developed millions of years by the ecosystem that exists there. It may be undeveloped because man hasn't built something there, but it may be very developed from a nature ecosystem point of view, very sophisticated ecosystems. But even our language doesn't really reflect what we want the status of nature to be, because it's built in all these assumptions in this English system of law, even a culture, the way that we talk about it. So Western system of law treats nature as dead, treats forests basically for their value to be harvested or timbered, treats rivers and streams and bodies of water as places to pull drinking water from. That's kind of how the English system of law functions. And so contrast that with how indigenous communities, tribal communities, see nature. Contrast that to the Ponca Nation in Oklahoma. It talks about speaking for those without voices, i.e. the flora and the fauna. The White Earth Chippewa, one of our clients in Minnesota, that talks about the flying people and the swimming people and the singing people. So it talks about nature as connected and animated as a living thing. The Yurok Nation in California talks about the Klamath River as being a relative or a living being. So a much different relationship with nature between this English system of law and an indigenous system of law, indigenous communities, the way they talk about nature, the way they treat nature within those systems. And I guess the one quote, before we move on to other stuff, but the one quote that really pins this English system of law to the wall to give you this idea of the disjunction between the two is from Sir Francis Bacon. We don't get the opportunity to talk about Sir Francis Bacon often, probably often enough or maybe too much. But what Sir Francis Bacon said, is an English philosopher, he said, the job of Western law, the job of Western civilization, was to, quote, torture nature on a rack to extract her secrets. Torture nature on a rack to extract her secrets. I don't think you could find anything further apart than torturing nature on a rack and talking about nature in terms of the flying people, the swimming people, and the singing people. Two completely different worldviews. And unfortunately, our legal system is stuck in one, not the other. And because nature is property, because that's kind of the theme that runs through the rights of nature stuff, is rejecting this concept that nature is property and can be owned, which is very much an indigenous concept, that our US Constitution recognizes certain values above others, like property and commerce. And once you recognize nature as property, you automatically are constrained in how you can protect the environment, because the US Constitution shields property ownership from certain legal decisions or laws that are made. So once you put nature into that category, once you put nature into that property category, once you put nature into that torturing nature on a rack category, you automatically constrain the society to protect the environment only in certain ways. And in fact, certain environmental protections can be stricken down as a result of their violation of property rights. So it's all connected. And I know this is kind of like drinking from a fire hose sometimes, but this is the system that we're stuck in, is that torturing nature on a rack kind of thing, and environmental regulations basically just chipping off the worst of these projects, but not having a mechanism to actually stop them, even if they interfere or damage the environment. So the question we get a lot at this point in time, presentation-wise, is so what? We're stuck in this system. How do you overturn a system, right? My God, we just wanted to stop this factory farm. Why are you pulling us into talking about the Constitution or talking about all these cultural and language stuff and how the system is set up, English structure of law? Well, the so what is that our path, at least, was saying maybe there is another system, not just an indigenous system, but maybe some of this indigenous concepts of nature have worked their way into the English legal system. And it turns out, back in the 1970s, ancient history, 1972, there was a professor named Christopher Stone. He was a law professor at the University of Southern California. Christopher Stone had a law class that he was teaching on environmental law, and it was after lunch. And it was a warm room. It was like in the summer or late spring. Students were falling asleep. And so to try to wake them up, Christopher Stone injected the idea of what if nature had standing, like ecosystems had standing. For folks that don't know what standing means, basically means access to the courts. So right now, courts are set up for people, no surprise there. But the concept that he raised was, what if nature had a right to go into court itself with people as guardians or trustees to actually prosecute cases that were damaging ecosystems, those ecosystems. So what if nature had standing in court? And that law class was so exciting that he decided to write an article about it in a law review. And the law review article was entitled, "Should Trees Have Standing?" That law review article probably would have died on the vine, like most law review articles do. I've written quite a few. They're gathering dust on the law school place where they put the books, but probably would have died on the vine, except that there was a case running through the courts at that point called Sierra Club versus Morton. The case name is not important. What is important is that the Walt Disney Corporation wanted to build a ski resort in a place called Mineral King Valley. For folks who don't know where Mineral King Valley is, it's east of San Francisco on the border with Nevada. It's where the Sequoia National Park is located now. And while Disney wanted to build this giant ski resort, usually all we have to say about it is that it would have been bigger than Disneyland. So a ski resort bigger than Disneyland, border with Nevada, east of San Francisco, 1.7 million annual visitors, 20,000 skiers, this huge development. Sierra Club didn't want the development to happen for a number of good reasons, and they sued. And the Sierra Club, as an organization, sued against the development, technically against the Secretary of the Interior, who was responsible for issuing permission for the development to go in. And the lower courts dismissed the case. They dismissed the case by saying that the Sierra Club didn't have standing, that to show standing to get into court, you have to show some kind of injury. You have to be injured as a person. You have to show some kind of injury to yourself. The lower courts ruled that the Sierra Club couldn't show that because none of the Sierra Club members lived there. None of the Sierra Club members could show that they had some kind of financial interest in the development, and the lower courts dismissed the case. The Sierra Club appealed it to the US Supreme Court, and in the US Supreme Court, the only thing that made this different from all other environmental cases to come before the US Supreme Court, because this case too was dismissed by the US Supreme Court, was a dissenting opinion. So the judges, of course, can write dissenting opinions to say we don't agree with the decision. The decision by a majority of the court was to dismiss the case, to affirm the lower court's dismissal of the case. Justice William O. Douglas, probably a kind of justice that we won't see on the Supreme Court for a long, long time, one of the most progressive environmental justices ever to sit on the Supreme Court, issued a dissenting opinion. And in the dissenting opinion, he borrowed Christopher Stone's law review article, Should Trees Have Standing? And for the first time in the US Supreme Court, he announced his dissenting opinion, which actually put forth the concept that nature should have standing in courts directly. That instead of, he opined, that instead of Sierra Club versus Morton, which was the name of the case, it should have been Mineral King versus Morton. In other words, the place itself as the plaintiff, not the Sierra Club as the plaintiff, but nature itself, this ecosystem itself, this valley itself should be a plaintiff. And so more appropriately, it should be called Mineral King versus Morton. That dissent kind of set off a flurry of talks and discussions about nature having standing and nature having some degree of rights in the courts. And then the question to us always is, what happened next? The answer is almost nothing. So the dissenting opinion comes out. People got excited about it for about 7 minutes. And then it kind of disappeared. This was 1972. So what happened next? Well, we started playing around with this concept of nature having standing. And we started asking ourselves the question of, what if we lifted this concept out of the dissenting opinion from the US Supreme Court and actually began to write local laws that recognized ecosystems as having standing and having rights? What would happen if a municipality, a city, a town, a village, a county, some place that was having an issue might want to protect themselves by recognizing ecosystems and nature as having rights, and then using that rights basis to try to stop whatever harmful project was coming in? So basically taking that Supreme Court stuff and making it into law, an enforceable law. So what happened with that? Well, in 2006, we had a client come in the door, a little town called Tamaqua Borough. For people who know Pennsylvania, it's northwest of Philadelphia. It's a small community of 7,000 people. It is not a progressive liberal place. It's a Republican place, kind of a red place in terms of color, 7,000 people. And they had a project proposed for Tamaqua Borough that had been proposed by the governor of Pennsylvania and Delaware to dredge the Delaware River, which gets dredged all the time, to lower or to increase the water body to allow commercial traffic to go up the river. The plan was to dredge the Delaware River and then take the river dredge and dump it into old mine pits in Tamaqua Borough. Tamaqua Borough is an old mining community. They have a bunch of open mines still in the community. The idea was to take the dredge and dump it into the open mines. One of the problems with that proposal was that the dredging from the Delaware River is full of PCBs, polychlorinated biphenyls, one of the most toxic kind of contaminants known to man, PCBs. And the people of Tamaqua said to themselves, well, we don't want to be a toilet for this dredge coming in. We certainly don't want to be contaminated with the PCBs and the possibility of pollution and plumes and all that kind of stuff. So we want to do something different here. So kind of this perfect storm. People of Tamaqua coming in, us re-examining some environmental law stuff, looking for a place to work with people to ground that concept of rights of nature. Turned out Tamaqua Borough was the place. They came to us and asked us to write an ordinance, write a local law that would ban the dredge from coming in and also recognize the rights of the rivers and streams within Tamaqua Borough. So Tamaqua Borough is situated in a place where they provide some of Philadelphia's drinking water through the Little Schuylkill River. They also have Wabash and Panther Creeks that run through the community. So they asked us, can we draft an ordinance using this kind of rights of nature concept to recognize rights for the rivers within the borough of Tamaqua, and then use that law to try to prevent this dredge project from coming in, or at least to protect the rivers and streams there from the impacts of that project. The law there had three common elements, and these are going to be the three common elements of all the rights of nature stuff I'm going to be talking about for the next couple of minutes. One is it recognized rights, most important part, recognized rights. So it recognized the river and the creeks there as having the right to exist, flourish, and naturally evolve. So kind of constitutionally based standards for waterways within Tamaqua. And then it provided who could sue, that people in the community could step into the shoes of the river or the creek to actually bring a lawsuit based on those rights as the waterway is the real party in interest in legal language, so that the waterway would be a plaintiff. And again, it's hard to get our brains around that, but a waterway is a plaintiff. And then finally, it provided for a remedy that the waterway had to be restored to its pre-damaged state. So the way to look at these early rights of nature laws are basically about three irreducible minima in the language of lawyers. One is recognition of rights. Second is who can sue, so answering the who question. And then third is the remedy section, about restoration of the waterways in this case. So those are kind of the three irreducible components of these rights of nature laws. So what happened next? Well, they passed the law. I think amazingly, to everybody's surprise, the Tamaqua Borough Council passed the law. And then the law began, news about the law began to travel. And we live in a very small world. It may seem big sometimes, but it's actually very small. The next call that came in was from Ecuador. And the people of Ecuador were drafting a new national constitution. And they had read about what had happened in Tamaqua. And they asked us to come down to be a consultant to the Ecuadorian Constitutional Assembly, known as the Constituent Assembly, where we went to Ecuador. We sat down with the committees that were drafting the new constitution. We told the stories of what were happening in Tamaqua, what was happening in Tamaqua. We told the story about the Supreme Court stuff and where the rights of nature stuff, the genesis was in the United States. And the drafting assembly, the drafting committees, actually included the rights of nature concept into the new national constitution, which was then overwhelmingly ratified by the people of Ecuador and is currently the new constitution in the country of Ecuador, making it the first country in the world to kind of transfer from a property-based environmental protection system, process and system, to a rights-based system of environmental protection. There's been quite a few cases brought now underneath those rights of nature provisions. Very exciting time for Ecuador as well, because the new constitutional court in Ecuador, which is the highest interpreter of the Constitution in the country, has now accepted a bunch of new cases for review that build on this rights of nature concept, including and they're reviewing outlawing mining permits in protected areas because it would violate rights of biodiversity within those areas. So it's a very exciting time. Prior to the Constitutional Court taking those cases now, we have about 60 enforcement cases that have been brought in Ecuador under those rights of nature provisions. The most famous one was the first one, which was called Vilcabamba River versus the province of Loja. It was a river as a plaintiff suing a local government for changing the river's flow by dumping road debris into the river. And the particulars aren't so important, but what's most important is it was the first case in which a judge ruled in favor of the river. So a river is the plaintiff, judge ruling in favor of the river as the plaintiff, and requiring restoration measures to happen for the river's flow not to be affected by that road debris. So Ecuador, first country in the world to actually put rights of nature into their national constitution. What happened next, as happens with these things, is it boomerang back around again to the United States. We were contacted by the city of Pittsburgh, which had an interest in banning fracking, hydrofracking for natural gas within the city. Believe it or not, there was an oil and gas drilling firm that had entered into a contract with the Catholic diocese to drill below the Catholic cemetery in the middle of the city of Pittsburgh. Can't make this shit up. That's how it happens. We want to drill underneath grandma and grandpa in the middle of the city. Got a lot of people upset. As part of that ban on fracking, we drafted an ordinance for the city council to review. As part of that ban on fracking, they asked us to put rights of nature provisions in to protect the three rivers, the Ohio, the Allegheny, the Monongahela. And then a unanimous city council passed the law back in 2010, recognizing rights of nature for those rivers within the city of Pittsburgh and banning fracking within the city as well. So a lot of people, when they refer to rights of nature, will refer to Pittsburgh. It's the largest, up until this past year, the largest municipality in the United States to pass a rights of nature law within the community. So a bunch of other quick developments here kind of at the end. We, up to this point, had been working on rights of nature laws as legislative vehicles, drafting a law and then passing it into law and then attempting to enforce it, or at least talking about what the coverage of that would be. Starting in 2016, something started happening that we could never foresee, which was that courts in other countries began picking up this concept and, without any laws in place legislatively, began to apply rights of nature principles through court jurisprudence alone. So no national laws, no local laws. Courts just began picking it up and calling it things like the new emerging international norm of environmental law. So that's the phrase that some of the courts started using. In 2016, the Columbia Constitutional Court recognized the Atrato River as having rights, one of the main tributaries within the country of Colombia, recognizing as having rights. Again, no law was passed. These were judges applying rights of nature as a new international norm of emerging environmental law. In 2017, a court did the same thing and applied rights to the Ganges River, so holding that the Ganges River had certain rights. In 2018, the Colombian Supreme Court ruled that the Amazon and the Amazon River Basin as ecosystems had rights, had legal rights, building off this development of rights of nature laws in other places. In 2019, the High Court of Bangladesh recognized all rivers in the country as having rights. So legally enforceable rights that accrued not to people living along the river, for example, but the river itself as having rights. So kind of international judicial development in those various courts. And of course, tribal nations. You know, we started with indigenous communities today with the talk. We've circled kind of all the way back around. In 2015, the first tribe in the United States, the Ho-Chunk tribe, voted as a tribe on a resolution dealing with the rights of nature. They were followed by the Ponca in Oklahoma, by the Ojibwe Chippewa, the Anishinaabe people on the White Earth Reservation in Minnesota, who applied the rights of nature to wild rice, their cultural staple for the Anishinaabe people, recognizing that rice had rights, the population of rights, the species itself had certain rights that could be legally enforced. The Menominee tribe in Wisconsin took a vote and recognized the Menominee River as having certain rights. The Yurok tribe in California recognized the Klamath River as having rights. And most recently, just a couple months ago, in our neck of the woods, if you're in or near Spokane, Washington, the Nez Perce tribe in Idaho passed a resolution recognizing the Snake River as having rights. So kind of tribal indigenous development, both in their tribal constitutions as well as in their tribal codes, but rights of nature laws being interlaced through those tribal developments, those tribal legal developments. Now, it used to be that talking about rights of nature would get you put in a padded room, so 20 years ago. And I remember giving talks. In fact, when Brian and I talked about doing this talk today, I looked back, it was 2007 when I gave a talk at Gonzaga, a law school, about rights of nature. Was traveling with a South African lawyer who was also doing rights of nature work. And back then, even though it didn't happen at Gonzaga, when you gave a talk about rights of nature, law professors walked out of the room because rights of nature was kind of this fringe concept, kind of radical concept. I think it's still not in the mainstream yet, but it's certainly closer than it has been. And that's evidenced by the fact that we co-hosted a rights of nature conference at Tulane Law School several years ago. So this is Tulane Law School hosting a rights of nature symposia. The dean of the law school came out in support of rights of nature concepts. So that was a big kind of watershed moment. One of the key professors there, Professor Oliver Houck, who was one of the authors of the Federal Clean Water Act, did a seminal law review article about rights of nature and has now embraced the concept of rights of nature. He's kind of like an elder within the environmental community. The Vermont Law School has held a symposium. It's like the premier environmental law school in the United States, has held a symposium on rights of nature. Most recently, the Levin College of Law in Gainesville, Florida, so University of Florida Law School, held a 2-day conference symposia on the rights of nature. And believe it or not, the Democratic Party of Florida has placed rights of nature into their state party platform. So the Democratic Party of Florida now supports rights of nature laws. And 5 years ago now, the Democratic National Committee, the DNC, actually put a rights of nature plank dealing with indigenous communities into their national party platform. So this is the DNC at the national level. So it's kind of gone from the isn't this a cute, quaint idea, to actually being given serious consideration by serious people towards moving and transforming and transitioning the existing environmental regulatory system that we have into something else, or heightening the protections from those regulatory systems into these rights-based laws. And I'm going to finish today with the place in the United States that became the largest community municipality to pass a rights of nature law, which happened this past November, so just a little over 2 months ago. People that are familiar with Florida, we always think of clean beaches and happy life and sunny days and all that kind of stuff. But Florida has been hit by water quality problems over the last 20 years. So whether it's red tide and algae blooms, you may have seen on the nightly news, these huge stretches of coastline which are dead from the red tide and algae blooms happening off the coast. Dead sea life last time I was in Florida, which was pre-pandemic back in February of this year. They were hauling dead sea life off with bulldozers and backhoes from the beaches. Dead manatees, dead dolphins, massive sea life kills. They have a real water crisis issue happening in Florida, and it ebbs and flows. Some years are better than others, but it's bad. And 4 months ago, Biscayne Bay, which is in the southeastern portion just below Miami in Florida, went to 0 dissolved oxygen levels. And I don't think we need to be a biologist or a chemist to understand that when it goes to 0 in the water column and you have no oxygen, which is necessary for life, that you have a dead bay. They actually killed the bay. That's the language that they were talking about in Miami, and that no life could survive. It was a huge, massive fish kill in Biscayne Bay. So what have the people in Florida been doing? Well, they said to themselves, existing environmental regulatory stuff has failed. We need something new. And they drafted a new law in Orange County, which is where Orlando is located. The county of 1.4 million people, so it's the 30th largest county in the United States. They wrote a rights of nature law in Orange County, which recognized the Wekiva, Econlockhatchee rivers and other waters in Orange County as having the right to exist, flow, be free from pollution, and maintain a healthy ecosystem. And that sucker, which went on the ballot in November, this past election day, passed by 89% of the vote. 89%, nothing. Anybody who's been involved in politics knows nothing passes by 89% of the vote. So it turns out people in Florida can't agree on anything else, pretty much, but they can agree on clean water. And that was the impetus for this. 89% of the vote, and now it's being copied in 30 other municipalities across the state under the arm of this group called the Florida Rights of Nature Network, which has been set up to basically take the Orange County experiment and begin to protect the Caloosahatchee River, begin to protect the Indian River Lagoon, protect Pensacola Bay, basically all the waterways in Florida that have been under assault, using this kind of model to protect those places. So so that's about it for today, for me at least, until we move to the Q&A. But all to say, I think it's probably the most exciting piece of what we do, this rights of nature stuff. The sky's the limit. You have new courts, a new court in Brazil just picked up the rights of nature concept the other day. We work in Australia, Nepal, rights of the Great Barrier Reef, rights of the Himalaya Mountains. We work with national governments as well as localities in the US, like beginning work with Charleston, South Carolina, on a climate bill of rights, recognizing climate as having rights. So there's all kinds of ways to apply this stuff, but I do think it's the next emerging trend in environmental law. Thank you.
Thank you so much, Thomas. That's really, I suspect, going to generate some discussion. So if everybody could, if you haven't already, you might want to open up the chat at the bottom of your Zoom window. If you're using the most updated version of Zoom, you should be able to use the reactions menu to raise your hand, and it'll create a nice queue for us. If you don't have the more updated version, you might need to open the participants window, and then the raise hand feature, it might be located there. So I will start at the top of my list here, which starts with Ren. I'm going to invite you to unmute, and if you could ask a short question to Thomas Linzey.
Hi, thank you, Thomas, so much. Can you hear me?
Yeah.
I'm a small farmer. I'm just totally thrilled and excited by this idea. Been following you for a while through Bioneers and such. And just wondering, as someone who's not an attorney, living in a very red rural area, how do I participate? How do I get involved? What's the best way to jump in here?
So Ren, where are you located?
I'm in Ellensburg, Washington.
Okay. So so this kind of presentation just touches on some of the basics. So we would set up a time with you. We now have a campaign team that can draft an ordinance, talk with you about the possibilities of navigating the politics of where you are. And then in Washington State, we're lucky because cities have the right to initiative. So even if your city council doesn't want to put something on the ballot or doesn't want to vote on something, you can override them with a citizens initiative, collecting signatures, putting it on a ballot, campaigning for it. We have a whole support network now that's set up to support those places that move forward with stuff. And so I can give you our contact information, and then we can set up a time to talk more about what the possibilities might be in your specific area.
A question that came up in my class as I transitioned to the next person, Thomas, was why rivers? And it seems odd on its face, given that they're so dynamic and changing. It seems, maybe the hardest thing to sort of clearly define. And there's a clear theme here. Is it just a coincidence, or is there something about rivers that has been a good reason for the focus?
I think it's a little of both. People generally move with rights of nature laws around things that they feel particularly attached to. And rivers are kind of that, or water bodies tend to be that for communities. But also the thing we haven't talked about, because this is kind of the basic kind of what is rights of nature talk, but rivers are not confined to municipal boundaries. So rivers flow outside of municipal boundaries. And one of the pieces of the rights of nature laws that makes it so attractive is that they can be enforced, at least on paper, extra-jurisdictionally. So the best example of this is in Pittsburgh, where there was dumping of frack chemicals upstream from where the rivers entered the municipal boundaries of the city of Pittsburgh. So technically, if the rights of nature laws were confined just to the municipal boundaries of Pittsburgh, couldn't do anything about it. But because they're rights of nature laws that recognize rights of rivers as they flow into the municipality, you could sue the upstream frackers to stop activities that are happening upstream that actually affect the water body below. And so I think that's one of the reasons why people are attached to waterways. But I talk about waterways because that's kind of like common denominator of a lot of the work, but they've been applied to glaciers now in India. So there's various different applications of the law, not limited just to rivers, but we found that rivers are kind of an easy entry point for people.
Troy Sims, feel free to unmute yourself, ask a question.
Thank you. Hello, Mr. Linzey. I'm Troy Sims. I'm a law student, which explains my dorky joke earlier, and also my even dorkier questions coming up. When you were describing how you were fighting regulations as part of the nonprofit firm, it reminded me of the reactionary culture around healthcare law and the whole healthcare culture in the United States. And it seems like it's a similar approach with environmental law. It's very reactionary rather than preventative. Do you think that explains the reluctance of applying this more protective system of, not system of law, but approach to the system of law, just this culture of reaction rather than prevention?
Yeah, I think it's a great question. I also like the poltergeist reference. So the reference, I think, in my mind at least, goes right to a kind of point about how we see ourselves as people. The communities that we work with have not seen themselves in the past as law drafters or lawmakers. You know, it's kind of like going back to medieval times when owning a Bible was illegal. You know, that you could be punished for that. You had to turn to the priests who were the translators. And I think today we've come a long way away from seeing ourselves as independent actors capable of doing that kind of work, seeing ourselves as lawmakers and law drafters. And so it's natural to me because we've been placed in this defensive system where the work that we do is all defensive. And as anybody who plays strategic games like chess knows, if you're always on the defense, you're always going to lose. That's just how it works. But we turn to others to help us in the problems that we have, like whether it's landfills or factory farms or whatever on the environmental front, and we get swept away into this environmental regulatory system, which provides a ready-made toolbox to do certain things, but of course doesn't reach where we actually need it to go. And so I think a big piece of this work, both with healthcare probably as well as with the environmental regulatory stuff, is that a lot of it is up here. It's in our heads. It's about what we're capable of. It's like on the pipeline stuff. You know, if we had 50,000 people that were willing to physically sit down in the path of a proposed pipeline, like the MVP in Virginia or Enbridge Line 3 in Minnesota, we could physically stop the pipeline. If we had a continuous, but the reason why we don't do that is because up here, we're not in that place. There's a colonization that's taken place. And on the healthcare stuff, you know, a lot of politicians talk about a right to healthcare. Right to healthcare doesn't exist in the US. They talk about right to healthcare, but there's nobody actually driving a legally enforceable right to healthcare into law. We've been talking with the Minneapolis City Council about doing something similar to that. What if it's a legally enforceable right? People have a right to healthcare. But you can go through all the, you know, Obama healthcare stuff and all through all the healthcare stuff that's been drafted. There's no right. Nobody ever creates a right. They talk about it to get political advantage about a right to healthcare, but it never becomes a right to healthcare. It's always written somehow differently, not to give a legally enforceable right. So I think there's a lot of comparisons between those two areas.
Next question is from Alessandra. Feel free to unmute yourself.
Yes, hi, hello. I just wanted to ask you, I mean, I understand that the rights of nature would, as a consequence, also benefit human beings. But since they are embedded in a system of human rights, what would happen when, like, the interest of nature conflict with the interest of human? I mean, how would the balancing of both interests, what would happen then if the interest of nature would always prioritize over the interest of nature, over the interest of humans? Sorry.
Yeah, I think it's a great question. I think we don't know yet, but we have courts that have dealt with similar kind of competition between human rights and human rights, like First Amendment rights, the right of the speaker versus the right of people to be free from hearing speech that they don't want, or property rights as they come up against First Amendment petitioning for citizens initiative or ballot qualifications. Courts weigh those qualifications all the time. What these laws basically do is for the first time put nature on the game board, because right now nature is not anywhere. And so there's no reason to to deal with those conflicting rights. What this does is actually puts nature in a position where you have to deal with the conflicting rights. So what happens at that point is anybody's guess, but if we're going to continue to survive on this planet, eventually at some point, the needs of ecosystems have to outweigh the needs of humans to exploit those particular ecosystems. So this is about, people always say, well, people are a part of nature, people are a part of ecosystems. Well, technically that's true, but our system doesn't treat it that way. Indigenous communities do, Western societies tend to not. So this is all about changing the dynamic so that at least nature is on the game board, and then making the argument that nature's interests sometimes need to be higher than people's, because if people's use of the ecosystem puts it at risk or danger of collapse, then it's kind of not the overriding interest there. There have been very few courts to look at rights of nature stuff in the United States, and none have gotten to that conflicting rights stage. So it's all a story to play out, kind of thing.
Thomas, as you know, in Spokane, this was twice on the ballot through ballot initiative here for rights for the Spokane River. I'm not sure if people in our community are still aware of that. It was resoundingly defeated the first time, but only lost by 500 votes or so the second time. Do you have any sense as to whether or not it's going to come around again in our community?
I don't. There's been some talk over the past 6 months or so about resuscitating rights for the Spokane River within the city of Spokane, having the municipal entity pass it. Also, maybe, I mean, this is just all guessing games at this point, but maybe tribes in the area picking something up. Yeah, the fact that it came that close is amazing to me, because it wasn't just rights of the Spokane River. There were 3 other things on the ballot in the same initiative. I think if it had just been rights of the Spokane River, it probably would have passed, but it failed by, I want to say, a little over 1% in the city of Spokane, which is kind of fascinating.
We've got our Riverkeeper a couple hands down on the queue, so maybe hopefully we'll get to him here, Jerry. But our next question comes from Professor Vera. Feel free to unmute yourself there, Luis.
Yeah, well, thank you for the very interesting presentation. So my question is, it seems that this approach of recognizing rights of nature is potentially more effective than the traditional one, which is essentially recognizing the rights of people in a clean environment. So I was wondering, why do you think that is, even though it seems we're really trying to answer the same questions under both systems, that is, who has standing to sue, and what are the remedies that are going to be chosen for violations of this right?
I think there are some commonalities, but I also think it means we need to be intellectually rigorous when we look at those different approaches, because a human right to a clean environment is much different in most ways than rights of nature, because the holder of the rights is different. And what that means is that the standing test is different to get into court. There's all kinds of things that are different about human rights to a clean environment rather than rights of a river, for example. So those are two, to me at least, two intellectually different areas, as is the public trust stuff. Sometimes people talk about nature as a public trust. The problem with the public trust doctrines is built on property concepts. So it treats nature as property, just commonly owned property, rather than owned by one person or entity. It would kind of be similar to being a slave back in the 1840s. You don't really give a shit whether you're owned by one slaveholder or owned by 200. You're still property under the law. So we have to be, I think, careful about this, talk about the commons and about public trust, because neither of those concepts elevates nature from being something else other than property. It just talks about commonly owned property. And again, this gets into the weeds. Some people would say, how many angels can dance on the head of a pin when we get into these conversations, but they have real on the ground impacts depending on how you start that first step. How do you lay the first stone when you're moving forward towards drafting one of these laws? So the rights of nature stuff is intellectually independent of those other areas of law. There's some similarities that cross over, but it's basically on its own kind of platform.
Patricia, please feel free to unmute yourself there and ask a question.
Hi, I live in Orange County, Florida.
Oh, great.
I've seen the rights of nature law passed. I voted for it. Woohoo. And this is a very broad, stupid question, but because the answer will take a day or more. But I've already seen incursions into that law by forces that can find just what you described as your example of, you know, people railroading over that, developers, sugar farmers. The roads are not protecting the panthers, which are full out environmentally endangered species. There's probably 11 of them left. So how do we fight the workarounds that people do against these laws? I'm not a lawyer. I will be happy to be active.
It's a great question. And yes, you should definitely hook up with the Florida Rights of Nature Network folks. I think Jim is on the call today as well. He's one of the principals. But the short answer to your question is that these laws, unfortunately, are not like flipping a switch. It's not like you flip a switch and everything's okay. It's all a question of enforcement. And I'm happy to report, because I think it's public knowledge at this point, that the Sierra Club in Florida, specifically in Orange County, has now brought a permit challenge. And one of the bases for the permit challenge to this massive housing development that's scheduled to go into Orange County is the Rights of Nature law that was passed in Orange County. So it's the first example of the Rights of Nature law in Orange County being used in this case, within a permit system to say you can't issue this permit because these waterways have rights within Orange County at this point. So it's going to be a question of enforcement moving forward with the language to make it real. But unfortunately, it's not like flipping a switch and everything's fine. Once you get to that point, it takes a lot of effort to actually enforce the provisions. And I think that's the rollout that's happening now.
Love to invite our Spokane Riverkeeper, Jerry White. You have a question?
Hi there. Hey, I just wanted to thank you all for this great presentation. GU and Thomas, thank you for this really enlightening conversation. And I just wanted to make a quick public announcement from Riverkeeper to say, if in our Spokane River watershed, if people are here in the watershed, there really are some great conversations going on right now about this subject. And we certainly resonate with everything that Thomas has said today. And I think it's not ready to unpack at this moment, but there will be ways to participate and get involved. And we're very excited about this entire line of thinking. So that's all I wanted to quickly say. Thanks again.
Did you just announce that you're advocating for the rights of Spokane River, Jerry? Just to put you very much on the spot. I'm pretty sure I heard you say that.
I gave you a preview that there probably will be an announcement at some day soon. Yeah.
Very good. Thanks for coming, Jerry.
Yep, you bet.
Stella.
Can you hear me now?
Yes, ma'am. Go for it.
Yes, great. Thank you, sir. So I'm Stella Tarn, and I'm with Capital Nature in Washington, D.C. And I just want to kind of acknowledge the wisdom of the choice of words of this. So Capital Nature was based on the notion that we positively engage with people with the natural world, kind of as a strategy, as a cultural strategy, and also kind of where we came to it from our hearts. And we left the heavy lifting, like to our friends at the Sierra Club, Nature Conservancy, all the lawyers. And basically, we just wouldn't touch the legislative stuff. We're like the good news people, right? As a strategy. But what's so interesting to me is that I could imagine covering the rights of nature in something like our newsletter. And so I just want to address, if you wanted to riff off of it a little bit. So if you were to speak about some kind of a river issue in Washington, D.C., and you talked about restrictive pollution regulations, which of course we do all the time, Anacostia River and so forth, there's a whole swath of people who just wouldn't want to get involved with that. But you talk about the rights of nature and the rights of the Anacostia River. I think you kind of open it up to a whole other population of nature lovers and explorers. And that's really interesting to me. And I wonder if you could kind of address the just that choice of that language and that approach.
Yeah, it's a great question. I think, some people like to talk about this work as rights of nature, because that's like the 30,000 foot level characterization of it, rights of nature. But I think the phrase itself kind of makes it hard to organize around, because people have a hard time getting their hands around something that's so amorphous and so big. I think the places where these efforts get the most support is when people talk about the rights of the Anacadia River, the rights of the particular river within their community, because there seems to be an adherence to, whether it's by fishermen or anglers, a recreational community around a particular river. That's not granola-y. It's not hippy dippy, just to use the phrase. Because when we talk rights of nature, it tends to be kind of hippy dippy-ish, and I'm hippy dippy, but it's a very narrow category. So when you talk about rights of a particular river, you're drawing in the anglers, you're drawing in the folks that use the river for recreation, other uses, and I think it's a much broader constituency. So when people at the ground level, and at any point in time, we're working on about 36 campaigns with localities across the U.S. who are at various stages of moving these laws into place. Our advice is always particularize it as soon as possible, to location it so that it becomes relevant to more and more people and doesn't tag this rights of nature thing, which is easy for people to characterize away. And on the question of constituency, I mean, in Orange County, we had anecdotal evidence of, and the numbers reflect this, Trump voters who had signs up for the Clean Water Initiative that passed by 89%. And so you have crossover. And in fact, this work began in very rural Republican districts in South Central Pennsylvania. So I think there are crossover points, but you have to be careful how you do the campaign. You have to particularize it as soon as possible, kind of get it away from this 30,000 foot thing and make people understand they can hold it.
On the issue of language, Thomas, and we're probably just about out of time, but I noticed that you used the term recognize. And am I right to assume that you used recognize instead of give intentionally, that you're recognizing the rights of nature rather than giving the rights to nature? And I'm a philosopher, so I can't help but point to the sort of the terminological difference.
Yeah, it gets into the weeds. It's like the Eskimos have 8 different words for snow, or whatever the phrase is that there are some within the rights of nature camp who believe that nature has pre-existing rights. And so when we talk about recognizing, we're recognizing something that's pre-existing. The problem is that there are people in the rights of nature camp who also believe that the rights don't exist until they're created through law. And so the word recognize is kind of a compromise between those two camps.
Gotcha.
So philosophically, there are people that come at this work from different directions. But from wearing my lawyer hat, the rights don't exist until you actually recognize them in law, on paper, and it has to be passed through a kind of municipal unit. They don't exist otherwise. So it's kind of a word use as a compromise in that area.
Well, thank you so much, Thomas. I've pasted again what you did earlier, which was the link to your organization, the Center for Democratic and Environmental Rights.
Mm-hmm.
And info@centerforenvironmentalrights.org. You can reach Thomas there. It's been a really enlightening conversation. I've also pasted there for everybody, and I'll paste it again, the links to our subsequent lecture series this semester. Our next talk is on February 9th with Professor John Cook from George Mason University, looking at use of climate misinformation. We're happy to co-host with the law school this March in just a few weeks, a really important symposium on environmental justice, race, poverty, and the environment. And I hope all of you will register for that excellent event. But thank you so much, Thomas. This has really been a fantastic discussion, and I imagine it's actually going to affect our community, as Jerry White was suggesting. So good timing, and thanks for coming.
Yeah, thanks for having us.
Thank you, everybody.